Good afternoon and good evening to everyone joining us from different regions of the world. It's a pleasure to contribute to this important exchange of perspectives on compulsory licensing from the BRICS countries. Our discussions will be initially based on some quick questions. So, what is the legal framework and legal grounds governing compulsory licensing in Brazil, India, and China? What specific circumstances these local laws permit the granting of such licenses? What is the procedural pathway and preconditions to apply for a compulsory license? And which authority has the competence to grant a compulsory license in each jurisdictions? Uh, so to address these questions, I will outline the Brazilian perspective and share some slides here. Can you see the slides? Yes, okay. So thank you so much. In Brazil, the main legal basis for compulsory licenses is the IP law 9,279, particularly in Articles 68 to 74. Additional provisions are included in Law 14,200, enacted during the COVID-19 pandemic, and the most recent law 15,122, which addresses international trade retaliation measures. So a compulsory license in Brazil may be granted on several legal grounds, such as the abuse of patent rights or abuse of economic power, failure to manufacture locally or to supply the domestic market properly, having an exception in case of economic unfeasibility when imported will be permitted. In case of public interest, for national or international emergency or public calamity. And finally, the dependent patent. When we have a dependent patent, I mean when a second patent cannot be exploited without using the subject matter of a prior patent, provided that the dependent invention represents a substantial technical advance and that negotiations have failed. Our law also provides provisions in case that the compulsory license will not be granted. And it will happen when there is a justification for disuse for legitimate reasons, proof of serious and effective preparations for exploitations, and in case of justification for the lack of manufacturing or marketing due to legal obstacles. The law of 14,200, it was enacted amending our IP law, dealing with compulsory licenses of patents in the following situations: national or international emergency, public interest, or public calamity. Some conditions are that it will take place only if the owner does not meet the demand, only for local manufacturing. The product may be exported in case of pharma. And there is something very interesting, that the federal government will publish a list with potential patents. So potential patents, granted patents, and pending applications subject to compulsory license, which will be published within 30 days after the emergency, calamity, or public interest situation is formalized. Exceptions: if the patent will not be subjected to compulsory license if under a licensing agreement. And in these cases of emergency, calamity, or public interest, so there is a period, it's not forever. And as an example, we have the COVID emergency, which ended in May 2022. It's important to notice that this list may contain also pending patent applications. So pending patent applications, even before the publication, may be subjected to compulsory license. And the royalty of 1.5% on net sales are foreseen. So the most recent law, the law 15,122, it was published last month, as you can see, April, last month, and it provides the federal government with a structured framework for adopting retaliatory trade measures, including suspension of IP rights. Although this law does not create a mechanism for compulsory licensing per se, it enables such measures in exceptional cases when traditional trade remedies are ineffective. Just to bring you a brief history of this law, it was derived from the Bill 2088, which was proposed in the Brazilian Senate, and it was initially introduced to deal with only with environmental issues. There were several reviews, amendments, and it, at a certain time, established a framework for Brazil to adopt unilateral retaliatory trade measures in response to foreign trade policies deemed harmful to Brazilian competitiveness, foreseeing suspension of IP rights. While this bill did not directly mandate IP suspension or compulsory licensing, in the end of the day, it created a legal basis for these measures. So after the reviews, this bill resulted in the law. But the most important difference, and it was a result of many discussions here in Brazil regarding the text of this bill. We succeed. We have an improvement in the text for the law, in the sense that now the retaliatory IP-related measures must be adopted only in exceptional circumstances, something very broad, and only when other measures are deemed to be inadequate to address the foreign actions, policies, or practices. So what are these other measures? It's in the law, the imposition of trade-related duties or the suspension of other commercial concessions. Anyway, in any case, the suspension of the IP-related obligations must be proportionate and aim to minimize economic and administrative burdens to Brazil. In general, a compulsory license can only be requested 3 years after the grant of the patent. And in theory, the Brazilian Patent Office is the authority competent to evaluate and grant the license. However, in cases of national emergency or public interest, the license may be granted ex officio by the federal government, and it happened with HIV cases. The patentee can oppose the license by presenting a legitimate justification for disuse or evidence of effective preparations to exploit the invention. After learning about these legal grounds, let's see how about the examples of cases. where for compulsory licenses, so we saw that in China, there has been no compulsory licensing granted yet, but let's see the examples of, of licensing granted, that we have a single case in Brazil, as well as initiatives that had been taken place in the sense of having a compulsory license. Uh, the Let me share my slides here. Can you see? Okay. So the first and single case that we had compulsory licensing granted, it was related to the pharmaceutical active ingredient efavirenz from Merck. And it was related to two granted patents. Uh, on So in May 2007, Brazil issued these first compulsory licenses for the antiretroviral efavirenz. It was declared to serve public interest under the National AIDS Program. It's very strong here in Brazil, this program. Merck had 7 days to respond to this declaration. A subsequent price discount was offered by the company, but it was deemed insufficient by the Ministry of Health. The license was issued for non-commercial, non-exclusive, and temporary use with royalties paid to the patentee. So the Ministry of Health discussed that there was a big difference in the prices, as you can see. So from one that $59, so a discount of 30% was proposed over this value, but the government paid so dot 45 cents of dollars per tablet. So there was no agreement on this case. A second case was actually a discussion, an initiative for obtaining a compulsory license. It's related to the pharmaceutical active ingredient neofinavir from Roche. And in 2001, a license was announced by the Ministry of Health, but withdraw the same day when Roche agreed to a 40% price reduction. The licensing was again considered 2 years later in 2003, but abandoned following successful price negotiations for multiple antiretrovirals. So at that time, the reduction was achieved for 5 drugs. Besides nofenavir, we also had the lopinavir, efavirenz, tenofovir, and azatanavir. A third example is the combination of lopinavir plus ritonavir of the drug Caletra from Abbott. In 2005, Caletra was declared to be of public interest. Negotiations took place, an agreement was reached, but civil society organizations still pushed for compulsory licensing through the courts. No licensing was ultimately issued. So this case illustrates that in Brazil, the compulsory license may work as a tool for price negotiations, and we have several. So I brought 2 examples of initiatives, discussions that in the end of the day, the negotiations on prices were achieved. Next, let's see as a final comment here regarding the when a party is not satisfied with this compulsory licenses. So what can be done? Let me share my slide here. What can be done? So the remedies. How about the remedies? Negotiation is part of this process, as we can see based on the examples provided. And if the negotiations does not solve the situation, a court action may be filed seeking to invalidate the compulsory licensing. The patentee must demonstrate that requirements for compulsory licenses were not fulfilled. And also there is the possibility to challenge the term and royalties established in the compulsory licensing through a court actions. So these are the mechanisms that we have to preserve the rule of law and ensure the process in decisions affecting patent rights. We have another question here, I guess, for all three countries. We have been receiving many questions. And so in case we are not able to have enough time, we will contact to revert with replies to this question. We have another question that is, in the cases discussed in the three jurisdictions, what were the royalties agreed? How were they calculated? So Manta would like to comment on this question.
Yes, so depends on the facts and circumstances of the cases, but generally the royalty can range from 3% to 6%. That is an average case, but there can be a situation where the drug is so expensive and the need is so imminent that the controller may reduce it even to 1%. So it all depends on what is the situation and what is the public interest demands in a given situation, you know. So for example, we talked about orphan drug, you know, and rare disease, where it becomes generally the rare disease are very expensive medicine, and rightly so, because patentee has really invested a lot of money thinking that it will be able to recover. But rare disease, as the name suggests, the population and the patient population is so small that the demand of the product is less. And the patentee is not doing a charity. Patentee has to recover that amount from the market so as to invest for the new invention. In such cases, it becomes a very tug of war. But if the public interest prevails and the situation demands, it can be a very less royalty as well. So there is no fixed formula. It is very dependent on the facts and circumstances of the case.
Yes, so thank you, Manta. I guess you summarized it very well. The situation here in Brazil is similar, but to give a reference in terms of royalties, general from 1 to 7%, depending on the technological area, and also as a result of negotiations and the real need for the country.